Langhoff Chambers webinar on an introduction to Ogden 8. I will say at the outset, if you have any technical problems or any questions throughout the course of the webinar this morning, please use the chat function. We will aim to answer any questions that we can at the end, time permitting. Otherwise, I think feel free to email us after the webinar. For those of you who don't know me, my name is Holly Tibbitts. I was called to the bar in 2010. And I did pupillage in Chambers and have been here ever since. I now undertake exclusively multi-track personal injury and clinical negligence work, up to and including claims for catastrophic injury. I'm joined today by Sabrina Hartshorn. She was called to the bar in 2001 and has been a member of Chambers for 3 years since relocating from Leeds. Sabrina has extensive experience in multi-track and high-value clinical negligence claims, and also with personal injury matters, in particular with expertise in multiple and significant injury claims, fatal accidents claims, chronic pain cases, and occupational disease. She's a contributor to the Kemp & Cam chapter on occupational diseases and has also published numerous articles in JPIL, most recently on discount rates and investment advice and Section 33 of the Limitation Act. So without further ado, let's get started. Today we're aiming to give you an introduction to Ogden 8 so that you are aware of how it differs from Ogden 7, and we'll also aim to demonstrate any new methodologies that have arisen as a result of the changes. I will be taking you through an overview of the changes, then looking at some general issues including interpolation and split multipliers. I'll then touch on loss of earnings claims, including contingencies other than mortality, and look briefly at quantification of pension loss. I will then pass over to Sabrina to look at application of the tables to fatal accidents and also to the new section on periodical payments. So let's start with the overview. What is new with Ogden 8? Well, first of all, there are some fully updated explanatory notes. There are new notes on life expectancy, an expanded section on that. Interpolation of multipliers and how to calculate split multipliers has been amended. I think now you should be able to see the full slides, and apologies for that. Yes, there's a new heavily updated section on contingencies other than mortality. There is a whole new section on calculation in relation to pension loss claims. It's just something that was sorely missing from Ogden 7. There is also revised guidance on dependency calculations in fatal accidents, particularly in light of the Supreme Court's decision in Nowa and the Ministry of Justice. And finally, a new section on the application of periodical payment orders. There are also new worked examples throughout the explanatory notes, which are a very useful way to understanding the application of the tables. What else will you notice on first looking at Ogden 8? Well, there are new tables. We've gone up from 28 tables in Ogden 7 to 36 tables in Ogden 8, and that is due to the addition of tables for loss of earnings to and pension loss from both ages 68 and 80. Obviously, the age 68 tables are particularly useful in light of statutory retirement age going forward. There are also new additional tables in addition to the 36 main tables, and I'll come on to explain those in a few minutes. The tables also now helpfully include the discount rates of minus 0.25%, minus 0.75%, and 0%, so no need to look at separate tables for those discount rates anymore. So what are the general changes to Ogden 8 compared to Ogden 7? Well, the first thing to be aware of is that there are changes to the underlying data upon which the new figures are based. The Ogden 8 data is based on 2018 mortality projections that were published at the end of 2019, whereas the Ogden 7 data was based on 2008 mortality projections. What this has resulted in is actually lower multipliers, which is somewhat counterintuitive, but the reason for that is because the 2008 Ogden table projections used to underlie the Ogden 7 multipliers have turned out to be too optimistic. Our life expectancy just isn't going up by as much as we expected. That means that generally at the same discount rates, your losses are likely to be lower on the basis of an Ogden 8 calculation than they would have been on the basis of an Ogden 7. In terms of life expectancies, there's been a reduction in life expectancy for about 1 year for men and 2 years for women. In the guidance notes, there is also some discussion of atypical life expectancies and how the table should be applied in those cases. And I would urge you to have a look at the notes to work out how the figure should be adjusted to take into account different life expectancies. So that's the first main change. The second main change is the addition of these new additional tables. The additional tables are available in Excel format to be downloaded from the Government Actuaries website. The tables can be used to identify multipliers from any age at trial up to any future age up to 125 years old. So that should cover near all future losses. There are separate tables for men and women, and the discount rates are minus 0.25%, minus 0.75%, and 0%. Importantly, these tables, like tables 1 to 34 or tables 1 to 26 under Ogden 7, do include contingency for mortality. And that's really valuable because there used to be no really good way of factoring mortality into account when you had a period of loss which didn't start or end at retirement age. The guidance notes say that where there is a need to interpolate multipliers from tables 1 to 34, that the use of the additional tables provides the most accurate and reliable multipliers. So what do they look like? Well, this is a screen grab from part of the tables. As you can see along the bottom, there are the various tabs for men and women at the very different discount rates. Down the left-hand column, the rows are the age of the claimant at the date of trial or assessment, and then at the top is the age at which the loss will continue until. So let's have a look at one of the scenarios in which the tables can be used, and that is in relation to interpolation of multipliers. Now, you'll be familiar with interpolation of multipliers from Ogden 7. It's sometimes necessary to interpolate where, for example, the claimant has a retirement age that falls between the retirement ages provided for in the tables, or if it's necessary to do an accurate calculation based on a precise age of the claimant, which is not a whole number. The explanatory notes for Ogden 8 set out 3 potential methods of interpolating multipliers. The first of which is the long method. That is a 6-step calculation which produces an accurate result, and it's exactly the same as the method that was provided for in Ogden 7. But there are 2 new methods. First of all, the simple method, which is a 1-step calculation. It provides an approximate result, which is probably good enough for advisory purposes, but might not be something that you want to rely on in a big schedule. And then there's also the use of the additional tables, which provide a very easy and accurate method of interpolating multipliers. I'm not going to look at the long method because you're all familiar with it from Ogden 7, but let's take a quick look at the simple method and the additional tables. In this example, we are looking at an interpolation between two integers. So we want to look for a life multiplier for a male aged 21 and 9 months, or 21.75. And how we do that using the simple method is we look at the multiplier for a 21-year-old male, being the age below that at which the claimant is, at a minus 0.25% discount rate, and we find from table 1 the multiplier to be 71.17, and that multiplier becomes x. We do the same for age 22, being the age above the claimant's age, and we get a multiplier of 69.89, which is y. And then you can use either of the two below formulae, x minus y times 0.75 because he's 21.75 years old, or y plus x minus y times 0.25. And that gives you very quickly a life multiplier for age 21.75 of 70.21. You can also use the method to interpolate between two different retirement ages. So let's take the example of a female age 45 with a retirement age of 67 at minus 2.5%. You get the multiplier for 65, which is the table below 67, and then you take the multiplier for 68, which is the table immediately above that for 67. Because 67 is 2/3 of the way between 65 and 68, you calculate x minus y times 2/3, or y plus x minus y times 1/3. And that gives you, again, very quickly, a multiplier to retirement age of 67 at 22.04. Now, what about the additional tables? Well, if you are using a non-integer, so the 21.75-year-old male, you still need to use the simple or long methods to find a more precise multiplier. But you can use the additional tables to quickly find a multiplier for losses to different ages. So let's look again at the example of the 45-year-old lady with a retirement age of 67 at minus 0.25%. You open the additional tables and you make sure that you are looking at the females minus 0.25% tab. Then you go down the left-hand column to find your age 45, and it's important not to get confused between what's in the left-hand column and then the numbers that mark the row number. It's easily done, but make sure that you're looking at the age and not the row number. And then you simply follow that across until you get to 67, which is the claimant's anticipated retirement age, across in the columns. And then you very quickly can see that there is the 22.05 multiplier, which is only 0.01 off what we got with the simple method. But as you can see, it's much easier, even than the simple method, to just quickly look up the multiplier in the additional tables, and it's more accurate. Now let's turn to have a look at variable future losses. The Ogden tables do not provide an immediate answer where annual losses and expenses are likely to change in future. Common examples of that are, of course, if the claimant's earnings would have changed as their career progressed, or if there are increasing care needs as the claimant gets older. Ogden 7 advocated the apportionment method to split multipliers in these circumstances. That involved a 6-stage process whereby the term certain multipliers were manually split into percentages, and those percentages were then applied to multipliers allowing for mortality to give the final figures. That method is still approved in Ogden 8, but the tables also provide for an additional simplified method using the additional tables, which is said to be the most accurate method. So let's have a look at how this works in practice. Let's take the example of a male who is 20 years old at trial, has a normal life expectancy and variable future care needs, so that between ages of 20 and 30 he'll need £30,000 of care per year. Between 30 and 50 that goes up to £60,000, and then from 50 onwards it is £80,000 per year. We can see from table 1 that the life multiplier in those circumstances is 72.46. Now we can then turn to the additional tables and look at the first period, 20 to 30. It's very easy. You go down to age 20, across to the 30 column, and you get 10.11. Then looking at the second period, you're in exactly the same row from age 20, but you now take it up to age 50, and you find that there's a multiplier of 30.86. But you need to deduct from that the multiplier for 20 to 30, which we found was 10.11. And so that gives you a multiplier for period 2 of 20.75. And then for the final period, age 50 to death, you take the whole life multiplier, and then you take off the multiplier from age 20 to 50, which we found in the tables as 38.86. And that results in a multiplier for that period of 41.660. And you can nicely tabulate it and then include your multiplicand and come up with the final figure, which is about 4.8 million in this example. So that's the general changes, how to use the additional tables, how to calculate interpolation and split multipliers in Ogden 8. Now let's move on to just talk about contingencies other than mortality. This is obviously relevant when undertaking loss of earnings calculations, and we're all familiar with tables A to D from Ogden 7. But the explanatory notes have been completely rewritten, and it's worth being aware of a number of things from the outset. Unlike the main tables, the data underlying the tables A to D has not changed. It's still based on 1998 to 2003 data, and that's basically because there isn't any better data available. However, the Ogden 7 figures were based on a 2.5% discount rate, and the ones in Ogden 8 are now based on a 0% discount rate. The tables encourage the use of reduction factors rather than resorting to a Smith and Manchester or Blameyer approach. And in fact, there has been a significant change in tone between Ogden 7 and Ogden 8, and it's worth reflecting on what the guidance in Ogden 7 was. Ogden 7 said that the use of the reduction factors was one method for dealing with contingencies other than mortality. And it said that if that methodology was followed, in many cases, it would be appropriate to increase or reduce the discount of the tables to take into account the nature of the claimant's particular difficulties. The tables A to D were regarded as a ready reckoner, and it was said that it might be appropriate to argue for higher or lower adjustments in particular cases. So there was very much the tone that the figures were a starting point and adjustments were anticipated. In Ogden 8, the tone is somewhat different. It says that applying tables A to D is the suggested method. In the majority of cases, this would enable a more accurate assessment to be made of future losses than, for example, applying a Smith and Manchester or Blameyer approach. It also says the reduction factor approach, which follows, is guidance and not prescriptive. However, the table A to D reduction factors should generally be used unless there is a good reason to disapply or adjust them. Albeit it is still accepted that there will be some circumstances where it's appropriate to depart from the reduction factors. And in fact, the Ogden 8 guidance now does address where departures may be appropriate and how that should be achieved. There are 6 new worked examples on dealing with contingencies other than mortality and loss of earnings claims, and they are well worth looking at when you're trying to get to grips with Ogden 8 in more detail. Let's have a look at the contingencies other than mortality one by one. Employment status is pretty straightforward and is basically the same as it was under Ogden 7. It's important to remember that when you're applying tables A to C, which are the non-disabled tables, it is the time of injury which is important in terms of the employment status, not necessarily your employment status at the time of assessment, which may be different. For example, if you might have lost your job due to COVID anyway, that subsequent to the injury, that doesn't mean that you should consider yourself as unemployed. The definitions are set out there on the slide. There is some guidance as to where a departure from the reduction factors might be appropriate. For example, if there has been a change of employment status around the time of injury or around the time of trial, which isn't really reflective of the claimant's career prospects. If the claimant has unusually secure employment, for example, being a member of a family business, or if the claimant is employed but with a checkered employment history, you may have to adjust the factors up or down. Next, disability. Now, this is probably the area that we're most concerned with. The conditions are set out in the notes. There are 3 conditions to be met for the claimant to qualify as disabled for the purposes of an Ogden 8 calculation. The person has an illness or disability which has or is expected to last for over a year, or is progressive illness. The Disability Discrimination Act 1995 definition is satisfied in that the impact of the disability has a substantial adverse effect on the person's ability to carry out normal day-to-day activities, and the effects of the impairment either limit the kind or the amount of paid work that he or she can do. Now, many of you will have noticed that the statute that's cited there is the Disability Discrimination Act 1995 and not the Equality Act 2010, which was mentioned in the old guidance notes. The guidance notes are at pains to point out that it is the DDA 1995 definition and not the Equality Act 2010 definition which is relevant, and that all 3 factors have to be met rather than just one. The difference between the DDA 1995 and the Equality Act 2010 is really in the guidance notes. But if you've been using the guidance notes set out in Ogden 7, they appear to be from the Disability Discrimination Act 1995 anyway, so you should be okay. There's obviously scope for interpretation on whether the claimant meets the definition of disabled. What is normal? Well, that's defined in the notes as something that's carried out by most people on a daily basis, including that carried out at work. A more difficult issue is often whether the claimant has a substantial adverse impact on his abilities. You have to look at the Disability Discrimination Act 1995 guidance notes, which are reproduced in the explanatory notes to Ogden 8 in part. It's worth bearing in mind that the threshold for what people consider substantial in terms of disability has decreased over time due to a reduction in the stigma surrounding disability and people therefore being more willing to self-identify as disabled. And this was in part the source of agreement in Billet and the MOD, which you'll all be aware of. The guidance notes point out that Mr. Billet was disabled under the looser Equality Act 2010 definition, which doesn't include the DDA 1995 guidance notes, but he may not have been disabled under the stricter Ogden criteria, taking into account those guidance notes. So in those circumstances where you're falling short of the disability definition, you may still be looking at a Smith and Manchester type award, as was the case in Billet, and it may be rather slightly more difficult to get into the definition of disability in light of the new guidance. What about a Connor and Bradman style departure from the disability reduction factors? Well, this is addressed in the guidance notes. They are keen to point out that there is a misconception that the impairment must be severe or moderately severe to qualify as a disability for the purposes of the calculation. That is not what's reflected in the underlying data. That 43% of the people in the underlying data had mild disability, 44% moderate, and 13% severe. So the takeaway from that is that disability in the context of the Ogden tables does not necessarily mean severe disability. And the guidance, in fact, says that as long as the claimant meets the definition of disability, a departure on the basis of a perceived mild impairment or activity limitation might not be appropriate. And conversely, you may therefore argue that if somebody is severely disabled, there may be scope for adjusting the reduction factors in the other direction. It's important to look at the disability itself rather than the impairment. A loss of a leg is obviously going to be less of an issue for an office worker than it is for somebody who has a history of heavy manual work. If it is found to be necessary to depart from the reduction factors, the guidance notes say do not just use a midpoint, as was the approach adopted in Connor and Bradman. Disability has a significant impact on employment prospects, and it says that using a midpoint between disabled and non-disabled is likely to be too great a departure and underplay the impact of the claimant's disability on his employment. And therefore any departures should really just be fairly modest rather than something halfway between disabled and not disabled. So that's disability. What about education? Key things to note from this is that the education levels have now been relabeled as levels 1 to 3. There's now a detailed list of which qualifications fall into which levels, so it's important to take instructions about the specific qualifications that the claimant has. In terms of potential departures, they're fairly common sense. For example, if the claimant's educational attainment does not really reflect their skill set, or for example, if the injury means that the qualifications and skills that the claimant has can no longer be used. For example, if a nurse is injured and can no longer carry on a nursing career and is limited to administrative type tasks, then it may be appropriate to disregard the nursing qualifications for the purposes of determining education in the Ogden calculation. So that's a whistle stop of contingencies other than mortality. Have a look at the worked examples because they're really key in helping to understand the application on the practical level. I'm going to quickly address quantification of pension loss. There are new guidance and worked examples of quantification of pension loss that deal with defined benefit schemes, which are obviously increasingly rare, defined contribution schemes, and also with automatic enrolment. I think that the automatic enrolment guidance is of the most interest at this stage because I think there's been some debate about the correct way of quantifying these losses. Just as a reminder, automatic enrolment is applicable to all employees earning £10,000 per year or more between the ages of 22 and retirement. And it applies to qualifying earnings currently between £6,240 and £50,000. The employer contributions are a minimum of 3% of those qualifying earnings, and the employee contributions a minimum of 5%. Now, the guidance notes provide a worked example, and it's interesting to note that the footnotes to the notes comment that many pension experts consider this to be too simplistic approach because it doesn't take into account actual pension loss at the end of the day, just the current loss contributions, and doesn't take into account pension tax benefits, pension fund management charges, or the potential for investment growth. But it's been adopted because in part this was the accepted methodology used in the case of Manor and Central Manchester University Hospital's NHS Foundation Trust, a FIT 2015 case. And it's now approved as a methodology within the tables. So again, it's relatively straightforward. It's a six-step calculation. In this example, we're looking at a 35-year-old female who is degree educated with a retirement age of 68 at a minus 0.25% discount rate. She's in employment. Pre-accident, she was earning £20,000 per year and was not disabled. Post-accident, she is earning £20,000 a year and is disabled. And the methodology is to calculate the but-for contributions. You take the earnings and their gross earnings rather than net earnings, and take off their qualifying earnings and multiply it by 3%. You do exactly the same, but for the residual contributions, so using the actual earnings figures. You then look at the multiplier to the relevant retirement age and multiply it by the relevant reduction factors from tables A to D. So you'll see there 0.88 when she's not disabled, goes down to 0.59 for disability. And then you do a simple calculation, apply your multipliers to your multiplicands, and then deduct the residual contributions from the but-for contributions. But the notes say that you do not deduct employee contributions from the loss of earnings calculation if you are undertaking this method. So there is a quick overview of pension loss. Again, there are worked examples, so have a look at those if you're needing to calculate defined contribution or defined benefit losses, but there's the automatic enrolment pension. I'm now going to hand over to Sabrina to talk to you about fatal accidents and periodical payments.
Right, well, thank you, Holly, for providing a useful insight into sections A, B and C of the explanatory notes that accompany the tables. I'm just going to try and share my screen with you now. There we go. I'm hoping that you can all see that. So if you just wait with me one moment, I'm just going to try and work out if I can actually, there we go, right. Well, my job today is going to be to discuss sections D and E in the new Ogden 8 explanatory notes. Now, section D deals with the application of the tables in fatal accident claims, and section E is a new section dealing with periodical payment orders. Now, looking at section D, since the Ogden 7 explanatory notes has essentially been completely rewritten, and a simplified approach has been adopted in the assessment of pre- and post-trial dependency and fatal accident claims. It essentially is setting out in detail a post-Nauer simplified approach. It also provides you with 3 new worked examples. Now, the reason essentially why we've got a complete overhaul of section D is in large part due to the Supreme Court decision in Nauer in 2016. The examples that you've got in sections D are examples 15, 16 and 17. I'm going to be using example 15 today and taking you through that. But just to let you know, example 16 is a Scottish example which takes into account the different discount rates that are applicable there. Obviously, as we know, the Scottish discount rate is minus 0.75% as opposed to our minus 0.25%. So the section provides us with a brief overview initially of dependency claims, and it's in fact worth reminding ourselves of the overview of dependency claims, and that the claim for dependency arises out of the Fatal Accidents Act 1976. And as long as one satisfies the definition of dependent within that act, then he, she, or indeed they can claim a proportion of the deceased's income or pension that the deceased would have spent on them. And services such as childcare, household tasks and DIY that the deceased would have done and from which the defendants would have benefited can also be claimed. So the dependency claim is split into 2. There are losses sustained in the period between the deceased's death and the date of trial, and also there are the future losses to be incurred post-trial. And the court will work out for each future dependency, for each dependent, a multiplicand, that's the yearly loss, and then a multiplier is applied to that multiplicand to achieve the overall lump sum for each head of dependency. So always remember what you're trying to achieve here. Essentially, what you're trying to achieve is that the compensation is intended to reflect the value of an income stream during the lifetime of one or more dependents of the deceased, but it is limited to the expectation of how long the deceased would have been able to provide the financial support had she or he not sustained those fatal injuries. So in order to understand what we do now, we really need to point out what we were doing before NAUR. And the assessment before NAUR was being done from the date of death, following the decision, the House of Lords decision in Cookson and Knowles way back in 1979. Now, the reason for this was that the deceased death effectively was the only certain event, and everything thereafter was deemed uncertain. The multiplier was fixed at the date of death, and then the period from the death to trial was deducted from the overall multiplier to give the multiplier to be adopted for future loss. The same discount rate was adopted for calculating multipliers as that applicable to personal injury claims by a surviving claimant. Now, that approach was heavily criticised way back in 1999 by the Law Commission in their paper on claims for wrongful death. They put forward that the assessment should be done from the date of trial. And indeed, way back in 2000, the fourth edition of the Ogden tables and the explanatory notes recommended a more just and more simplified approach, which did take the assessment from the date of trial. And in fact, that approach, which was outlined in the fourth edition of the Ogden tables and the subsequent editions, was in fact adopted into law in Scotland by the Damages Scotland Act 2011. So what was wrong with Cookson and Knowles and the way that they did it then? Well, it was all really a little bit too complicated. A simpler method was required. And given the decision in Wells and Wells, the starting point was for calculating multipliers should be essentially the Ogden tables. Thirdly, it was really wrong to apply a discount rate before the trial, as the dependents hadn't really received their damages and couldn't achieve the investment return that the discount rate presumed. Also, contingencies post-death and pre-trial were in most cases low and did not justify applying a discount rate. And essentially, the whole approach appeared arbitrary and illogical. So what happened in the decision of NAUR and Ministry of Justice? Well, the Supreme Court overturned the two previous decisions of the House of Lords. That's the one in Cookson and Knowles and Graham and Dodds. And the reasons given for overturning that decision was primarily due to the decision in Wells and Wells, the 1999 case, that namely the adoption of the Ogden tables, that really was your starting point. And the Ogden tables themselves, because they've become more prevalent and more important, they had fundamentally changed the legal landscape. So therefore, they held that multipliers in fatal accidents claims should be done from the date of trial, bringing fatal accidents in line with ordinary personal injury claims. So what were we doing before Ogden 8? Well, this was the approach that was recommended in Ogden 7 for post-trial dependency. You would determine the expected period from the date of trial for which the deceased would have been able to provide the dependency. You would determine the expected period for which the dependent would have been able to receive the dependency. You would take the lesser of the two periods, treat the resulting period as a term certain, looking up the figure in table 28, which is now the new table 36 in Ogden 8, and apply the appropriate discount rate. For earning dependencies, you would employ a employment contingency factor in accordance with section B, tables A to D, and also make allowance for the risk that the deceased might have died anyway before the date of trial using table F. So looking at the explanatory notes in Ogden 8, the working party has set out in detail how one goes about assessing dependency from the date of fatal incident to trial and then for post-trial dependency. In post-trial dependency, they essentially split post-trial dependency between pre-retirement damages and post-retirement damages. The methodology they recommend is based on the principles, they say, which were endorsed in NAUR, but using tables 1 to 34. And they believe that this is going to yield reasonably accurate outcomes for most cases. So let's have a look at how to assess the dependency for the period from the fatal incident to the date of trial. Well, in my view, this is the more simple calculation. The dependency loss obviously normally runs from the date of incident causing the fatal injuries, but sometimes that can be later. And that can be later, for example, if there is a period between incident and death and the deceased continues to be paid by the employer until he passes away. We need to be alive to the fact that account should be taken of any likely reduction in dependency prior to the date of assessment or trial. And an example of that would be a dependent child, for example, reaching the age of full financial independence before the trial date. And of course, a small discount needs to be made for the risk that the deceased might have died anyway between death and trial, and that's Table E, which we'll come on to in a moment. But just to let you know that in relation to that, it is a small adjustment on the whole, but an adjustment does become more necessary the longer the period from the date of death to the date of trial, and the older the deceased is at the date of death. And obviously interest is then added to, not to the date of trial, well, it is added to the date of trial, but interest is then added to your figure as you would for special damages. Now, I have, in the next slide, replicated Table E for you, as you can see there, and we will come on to Table F in a moment, but just a word on Tables E and Tables F and how the adjustment is arrived at. Now, both tables are based on the assumption, we're told in the footnotes to the explanatory notes, that the assumption of a date of death of 2020, and for most fatal accident cases reaching trial between 2020 and 2025. The tables have also changed since Ogden 7 in a few ways. Well, firstly, they will take into account the reduced life expectancy given the reliance on the 2018 ONS statistics. They now go up to the age of 90. In the last edition, they were going up to the age of 80. And they now provide a reduction factor essentially for every year for a period of 10 years. You may recall in the last edition, you were looking at Tables E and F, were doing it every 3, 6, and 9 years. And then you were going to have to do an interpolation calculation. So this is making it a lot easier. There is a difference when you look at the factors between Tables E and F. There is a difference between the factors in the two tables. And you may ask yourselves, well, why, if this risk is so negligible? Well, the footnotes tell us that Table E represents an average survival period from the date to which an element of damages relates up to the date of trial. And then Table F represents a point-to-point survival ratios of a fixed number of years from the date of death. So hence the difference. Now let's take a look at example 15 and look at how the simplified assessment works for pre-trial damages. So example 15 is this: a sole financial dependent woman aged 38 at the date of trial. The trial's taking place 3 years after the date of a fatal accident. And that fatal accident killed her husband, who at the time of death was aged 37. He would have been age 40 at the date of trial. He had A-levels, was in employment, not disabled. He lived and worked in London. So we've got the England and Wales minus 2.5 discount rate being applicable. There was no evidence suggesting that either the deceased or the dependent had atypical mortality risks, nor was their relationship deemed to be unstable. So in relation to this example, the court had determined that the multiplicand for pre-retirement damages up to 65 was 30,000 and for post-retirement damages £12,000. So the period between the accident and the trial was 3 years. And we know that an adjustment needs to be made for the risk of possible early death under Table E. we've got the multiplicand of 30,000, we multiply that by the 3 years, multiply it by that risk under table E. And just to go back to table E to show you, you can see below 40, the age the deceased, the male deceased was, he was 37, so you would look to below 40 on the left-hand side, and then go across to 3, which is the period of years, and there we have 1. So that's £90,000 plus interest at half the rate from the date of death to the date of trial. So far, so simple. Now on post-trial dependency, obviously the explanatory notes set out that there are 3 main classes of dependency. You've got your earnings, your pensions and your services, and then out of that come 5 main dependency claims. The first one is the loss of earnings to retirement age. The second is loss of earnings for a shorter period, and by shorter period I mean if the dependency or the earnings change or end. And thirdly, the loss of pension for life of the deceased or the dependent, if that is shorter, and the loss of services for life of the deceased, again, or the dependent, if that is shorter. And then finally, the loss of services for a shorter period than the life of the deceased or the dependent. And each type of dependency is going to require a separate calculation using a different multiplier. Now, the methodology used is very similar and can be followed for each dependency that requires a calculation. So how do we go about acquiring that multiplier for post-trial dependency? Well, firstly, we need to be looking at duration of dependency. Now, that's limited, as I've mentioned, by the deceased or the dependent. There's normal life expectancy is presumed, so 0% column in tables 1 or 2, unless there is an impaired life expectancy. And there are 2 periods that need to be determined. The expected period from the date of trial for which the deceased would have provided the dependency in question, and secondly, the expected period from the date of trial for which the dependent or dependents would have received the dependency. And it is the shorter of those 2 periods from the date of trial which provides you with the basis of the multiplier for the dependency. So let's go back to example 15 and put what I've just said into context. We reminded ourselves of the example. I won't repeat it there. But to help you, the post-trial damages, you can, if you can remember, were split into pre-retirement and post-retirement. So let's deal with pre-retirement. So expected period for the dependent receiving the dependency is this. We've got a female, she's the dependent, she's age 38 at the date of trial. We look to table 2, that's for females, and we go down to the column for a female age 38, and the period is, the multiplier is 49.73. The deceased age at trial is 40. If you add those 2 together, it's 89.73. Therefore, the financial dependency essentially will be for the entire period of the deceased's employment. And we know from the example 15 that he would have retired at age 65. So what we're going to, the lesser period here is the period for the full period of employment. So it's a multiplier for a male age 40 retiring at 65, and you're looking at Ogden table 9, which gives you a multiplier of 24.97. Looking at post-retirement, the expectation, you have to consider the expectation of the life of the deceased at the date of trial. So he's a man, he's age 40, you're looking at table 1 again on 0%, at 44.80, the multiplier. Expected period for which the dependent receives the dependency, well, we know that her lifetime multiplier is 49.73. The lesser of those 2 periods is the life expectancy of the deceased, which is 44.80. So we are going to be extrapolating from the tables the multiplier for male from age 65 for a male age 40, that's table 25, and that gives you 22.66. Then after you've considered duration of dependency, you're going to need to consider discounting that multiplier for contingencies, essentially other than mortality. Now, the explanatory notes remind us to avoid double discounting, and essentially what they're doing there is they're reminding you of any adjustments you make to impaired life expectancy, etc. So they essentially outline 5 categories of contingency, with the proviso that in most cases practitioners will only need to concern themselves with categories 1 and 2. That is factors relating to the deceased's earnings, so that comes from section B, tables A to D, and a deduction if appropriate for the risk that the deceased might have died anyway before the trial, and that's table F. They say it is rare, but you may need to make a further adjustment for atypical health or mortality risk. And then fourthly, they ask you to consider adjusting for contingencies after retirement age. Now, we do know, just pausing there for one moment, we do know that the pension tables already take into account mortality risks. Now, when one looks at the explanatory notes, what it says about this is that some reduction to the multiplier for loss of pension would often be appropriate if you're making a reduction for loss of earnings, but the scale of the adjustment is really dependent upon a number of factors, specifically to the pension rights themselves. So you really need to know the type of pension and the benefits, etc., that you're going to be getting, that the deceased would have got from those pensions. Of interest, actually, is in the 3 worked examples that have been provided in the explanatory notes, they don't, in fact, provide for any contingency post-retirement on the pension. I don't know why, but they certainly don't provide it within the example. And finally, we've got the last category of contingency, which is factors relating to the relationship of the deceased and the dependent. Well, what do I mean by that? Well, that's where you have an unmarried couple, for example, on the point of separation before the deceased has died. And so there can be a reduction factor that is calculated to reduce the overall multiplier. So let's go back to example 15 and deal with discounting for contingencies. I've repeated the example there for you. Pre-retirement damages, the deceased he's employed, male, age 40, with A levels, so we're looking at a level 2. We know he's not disabled. The reduction factor is going to be 0.87. We know that the pre-retirement multiplier was 24.97, so we merely multiply the 24.97 multiplied by the 0.87, and we come out with 21.72. Then we obviously have to apply the deduction for a risk that the deceased might have died anyway before the date of trial, and that is when we look at table F. So again, we are looking at a man and he was deceased at the date of death below 40, 3 years it took to come to trial. So we're going to be applying 1 for that reduction factor. So on pre-retirement damages, we currently have a multiplier of 21.72. We make the adjustment under table F, it remains at 21.72, and therefore we come out with £651,600. Post-retirement damages, we have the multiplier of 22.66. There is, in this particular example, no reduction made for the pension, but there is adjustment for an adjustment under table F, which again is 1. Again, that doesn't affect the multiplier, so you're essentially multiplying the 22.66 by your multiplicand, and you get £271,920. And then you essentially add them all up together to get your total. Now, at paragraph 143 of these explanatory notes, the authors of the explanatory notes have provided a basic step-by-step approach to calculating dependency as a whole. So they start, and I've set these out for you in these slides, they start with saying you must calculate the annual loss based on the value at the date of trial. So go and assess your multiplicand. For earnings and pension, apply appropriate dependency factor where there are dependents and when there are no dependents. So we're looking at the 75%, 66.67%. Work out then your duration of dependency and discover your multiplier by utilizing the most appropriate table from the Ogden tables: lifelong losses, tables 1 to 2, losses to retirement age, tables 3 to 18, tables 19 to 34 for pension losses, and tables 36 for losses of fixed periods, which cannot be derived from tables 1 to 34. Now, just pausing there for one moment at point D, you will have probably noticed that this is different to the recommended approach that was being used by us post-NAWA. We were obviously encouraged to use table 28, now the new table 36, rather than using tables 1 to 34. And you may be thinking, is this affecting the value of your claim by using tables 1 to 34 as opposed to tables 36? Well, the short answer to that is that it does. And using example 15, pre-trial retirement damages, if we looked at that, they were £651,600. If I use table 36 for my assessment, the figure I would actually come out with is £673,500. We're looking at about a £20,000 difference here. Now, whilst on that basis, you may think that the recommended approach in Ogden 8 is not as beneficial for the claimant, it is in fact the more realistic approach using tables 1 to 34, because they take into account mortality risks, whereas tables 36 have no adjustment for mortality at all. So just then going back to the summary, you're to make adjustments for earnings related contingencies. Then you're also to query, so you're to make an adjustment applying table F, and then you are to query if adjustments need to be made for atypical health or mortality risks, pension losses, factors relating to the dependent's relationship to the deceased. And from then you will have your resulting multiplier, and you can apply that to the multiplicand for post-trial dependency. So there is a section in section D on what to do if you have multiple dependents. Well, in fact, usually in cases like this, we do find ourselves with multiple dependents, and we all know that they generally have several periods, different periods of dependency. And so the explanatory notes provide us with two options on how to deal with that. They say the first option is using a single multiplicand for dependency, and to be determined to be shared amongst the dependents, and the multiplier calculated utilizing the longest of the expected periods for which any dependency might last. And so that's normally based on the youngest child who no longer becomes dependent. Now, if the dependencies are truly independent of each other, they give you a second option, which is to separate the multiplicands and multipliers determined for each dependent. And then you can add the separate components to get to your post-trial dependency. This latter approach is certainly helpful when you're assessing apportionment between dependents for the purposes of any court approval or court assessment of any award that needs court approval. I appreciate it may be a laborious exercise, but ultimately it may be worth it if you go down the number 2 route on multiple dependents. So that's all I wish to say about fatal accidents and what the new section D says. I'm going to briefly discuss Ogden 8 and the periodical payment orders. Now, Ogden 8, as we all know, and the Ogden tables are all concerned with achieving a lump sum figure equivalent to capitalized value of future losses. So the introduction of a new section E here on PPOs appears really to come out of left field, because PPOs are a completely different beast to a lump sum award. And looking at the introduction to see the reasons why we have this new section on PPOs, there doesn't really appear to be any reasons for introducing this new section, but only the usual thanks to those providing their expertise on the subject. What I would say about periodical payments is that they are an important alternative to consider in your very high value claims, where you may feel that a lump sum award is not going to provide you, your client, should I say, with full restitution for any injury they have sustained. Now, I'm not going to go into the pros and cons in this talk of PPOs, and indeed PPOs themselves, in fact, probably require their own talk. What I'm going to confine myself to, and briefly, is essentially what Section E says on the subject of PPOs. So what does Section E provide us with? Well, it essentially provides the practitioner with an alternative, suggested alternative measure of indexation of loss of earnings in periodical payments orders. It deals with the application of suggested Table A to D reduction factors, and it shows you how to uprate for different earnings-based measures of inflation. So what does the section do? Well, the explanatory notes remind us of how the personal injury discount rate is set in England, Wales, Scotland and Northern Ireland. It also essentially espouses the benefits of an earnings-linked periodical payment, saying that really they are the only reliable way to closely match changes in earnings-based losses and expenses which may occur. And if you do wish to utilise periodical payments, utilise a periodical payment for future loss of earnings, you really need to be concerning yourself with two aspects. The concept of indexation, or the measure of indexation, should I say, and accounting for residual earnings capacity through reduced earnings growth, and reduced employment prospects. So there is helpful guidance on indexation. It provides you with what indexation means. It tells you what the default measure is, which is the RPI. And then it goes on to discuss how the court essentially can apply an alternative measure for indexation of periodical payments, provided your case meets the Mackay test. Now, I haven't produced the Mackay test in my slides here. It appears at paragraph 168. They have replicated that in the notes for you. And one alternative measure, if you're dealing with a care claim, for example, is by reference to earnings of those within the Standard Occupational Classification, SOC, of ASHA for care assistants and home carers. And that was a preferred way of doing it in the case of Tomstone, the 2008 case of Tomstone. The reason why they did that was that it was more statistically reliable using that measure rather than the RPI. There is much discussion on alternative measures of indexation, and in fact, again, I could do a whole talk on it. But ultimately, the upshot within Section E is that expert advice really is going to be required for a suitable measure of indexation in your substantial cases. There we have it. It then goes on to residual earning capacity, and essentially what it does, Section E, is in a case where you're uprating your periodical payments for loss of earnings to take into account post-injury residual earning capacity in a different role, they suggest a formula. And they suggest that you draft two separate schedules to your PPO, establishing two separate indexation calculations using the following formula. So your periodical payment is A times B times C minus D times E times F. What on earth does that mean? Well, what I've set out for you there is what A to F effectively means. Now, just as a conclusion to this whole talk, I just wanted to really sort of set out the pros and cons of this new Ogden 8. So what are the advantages of Ogden 8? Well, they've provided us with more explanatory notes on the whole. They are more detailed, they provide greater clarity, certainly in respect of fatal accidents. They have provided a more simplified and more detailed guidance on the assessment. There has been, in my view, a welcome explanatory note on assessments of pension loss. And there's also been a welcome discussion on life expectancy and the guidance that life expectancy evidence should not be sought from life expectancy experts unless there is a significant difference, explaining that tables already account for and cater for variability and lower life expectancy. There is a greater accuracy in assessment of future losses by reference to the 36 tables that we now have in Ogden 8. And what are the disadvantages or the cons? Well, we've got a lower life expectancy, but there's not really much we could do about that. There's a stricter definition of disability, although there is some scope for argument on that. And in my view, there is really a greater leaning towards more mathematical calculations and less scope for interpretation and argument. But as any lawyer will know, that where there is an argument to be had, we will always find a way to make that argument. So that's all from Holly and me. I want to thank you for joining this webinar. We are now happy to take any questions that you may have. I'm going to just stop sharing my my PowerPoint. And if you have any questions, please feel free to put them in the chat or the question and A section. If you don't have any questions at the moment, I'm going to give you a few seconds. But if there isn't anything, what I would say is thank you again for joining us and for attending today. We hope you found it useful and helpful. And if you do have any questions and you want to email either Holly or me directly, we are more than happy to answer any of your queries personally. I think that's it, isn't it, Holly? Really, we don't have anything else to say. I don't know if you know. There's no questions. We've obviously answered everything that needs to be answered about Ogden 8. So very pleased about that, and thank you very much for attending.
Thank you.